Hi folks, and welcome back to the videos for Contract A for week 2. We are looking at intention to create legal relations. This is part 2 in the series. Don't know if it'll be the final part or whether there'll be another part, but anyway, let's get back to the Prezi. Alright, let's start our examination of the Homogenous case. Why do I start here? I understand that your study guide, much like most of the texts in the area, still tends to default to a discussion of presumptions and the various different kinds of context that a contractual arrangement might be said to arise in, like family relations and non-familial relations and business contexts and so forth. Wilmot does it. Graw also does it, but to a far lesser extent. Why do they do that? Well, the law does change at a glacial pace. It just forward very hesitatingly, and so it's sometimes reluctant to let go of what's gone before and forge on into a brand new way of doing things, for very good reason. You know, you don't want massive changes in the way that judges look at a case to be happening all the time. For writers, authors like Wilmot et al. And also Graw, it means that an entire chapter can be thrown out the window, quite a bit of hard work, and so they're kind of reluctant to let go of all of that stuff. Guy would say let go, build a bridge. It's useful to know what went before, and that's the whole reason we have, historians helping us, legal historians help us understand where we've come from so that we can more fully appreciate where we're going to. Having said all of that, given that Homogenous happened in 2002, we need to perhaps start our discussions with what has been laid down by the High Court some time ago with a fair amount of authority, in terms of working out what our default step should be when we're answering legal problems, for example. So what were the facts all about? I'll just go through them briefly here, but you'll obviously have a much better understanding of the facts having done your case note on this case. As I've been banging on about in the first video, facts are always going to be super important whenever you're discussing intention to create legal relations, because they're going to establish that matrix of circumstance that you're going to be forensically fossicking about in order to see if the parties intended to create legal relations. But there's also another reason why facts are important, particularly when you're talking about this area of law. And you can, well, I guess it's pretty much important for most areas of law and contract, which is such a common law precedent heavy area of law. But particularly here, where you used to have a whole set of presumptions applying, the presumptions, as you all know, apply to various different kinds of relationship. And there are a nice little line of authority, many different lines of authority, a line of authority on family, non-familial relationships and so forth. And so where you're looking around in the facts of a case, you can, given that we used to have a set of presumptions, you can look at those previous classifications of relationship, and you can look at the cases there and you can kind of say, is there any overlap here? What were the indicia in those cases that either led to the court finding intention to create legal relations or not? So the facts are always important for contract law, but particularly here where we're looking at intent, they do help you then spot, okay, well, a presumption of this kind used to apply here. What did those particular cases say? And then you can go about either following them or not following them. So, facts of Homogenous. The Archbishop had been employed for around 20 years by the community. The community paid him. Interestingly, they also paid him his paid the ATO his PAYE tax, and on his tax-related forms, the community had designated Homogenous as the employee and themselves as the employer. So you have your first little possible hint that this might be a contractual relationship rather than a non-contractual relationship. There were other indicia as well. Homogenous resigned in 1993, so like I said, more than 20 years worth of service. Claimed unpaid annual leave and long service leave. So it wasn't a whole lot in terms of quantum that was being fought over, just over about $30,000, I think it was. But there was this obvious vested interest in proving each party's side correct, because not only did it initially go up before an industrial relations magistrate, it then went to a single judge of the Industrial Relations Court. It then went to the full court of the Industrial Relations Court. It then went to the full court of the South Australian Supreme Court, and then it finally wound up in the High Court. And there was some fairly stern finger wagging about all of that at the end of the High Court's decision, in the majority decision. So that is the facts in a nutshell. What were the two main issues? Firstly, whether or not the full court of the SA Supreme Court was wrong to hold that there was no intention to create legal relations between the Archbishop and the community. And the second issue was whether the full court of the SA Supreme Court erred in making the findings of fact that it did. So here we start to see some of the benefit of looking at the actual case rather than just the extract in the casebook. Okay, obviously you can't afford to read all of the cases that we cover in Contract A or Contract B in full online all the time. But where a lecturer does flag it for you, it's really useful because you do get a much deeper understanding of the facts of the case. Wow, my computer's telling me that term 3 is starting tomorrow. So what did the majority say about the issue? Well, we have Gordon, McHugh, Hayne and Callanan joining in the majority judgment. Obviously, where you've got a 4-to-1 split and you've got a 4-judge majority judgment, it's going to carry a heck of a lot of weight. I really like this judgment because of the way that they go about their reasoning. Nice and clear. The steps proceed from one to the next very logically, and it's great for beginner law students to kind of follow through what they do and note their reasoning on the way through. Firstly, where do you start in a majority judgment like this? Obviously, they have a look at the facts and so forth and the history of the case. But when they're getting down to tin tacks, the first thing they do is very sensible. They reiterate the basics, okay? What do we need to look at in terms of whether or not a contract was validly formed and legally enforceable? You have to have a set of parties. They have to be identifiable. Now, there are obviously caveats around that, as we saw with the Carlisle case. However, the run-of-the-mill contract will have identifiable parties. The terms have to be certain. You have to have an offer that contains certain terms that gets accepted. Unless it's a deed, you need consideration. So in your reading for Graw this week, you would have had a look at the difference between simple contracts that require consideration in order to make them legally enforceable, or if there's going to be some kind of lack of consideration, then you need to fix that up by the form that you place your contract in, and it has to be couched in terms of a deed rather than a simple contract. So generally speaking, you'll need consideration. But even where you have all of this other stuff, the circumstances may in fact show that the parties didn't intend their agreement to be justiciable or adjudicated by the courts. And this is where the whole intention to create legal relations issue crops up, okay? nice little statement of, okay, here are the basics. Then they go on to say, well, what's the problem here? What's the challenge where intention to create legal relations is raised in a matter? And they say, well, obviously, the challenge for a judge is just the huge range of circumstances that you need to actually take into account if you're going to make a satisfactory conclusion on whether or not the objective facts indicated that the parties intended, subjectively intended, to create legal relations. So you're only looking at the objective stuff. You're looking at things like subject matter of the agreement, status of the parties, relationship of the parties, and other surrounding circumstances. I love that. This may be your first encounter with what lawyers would call the global caveat, the catch-all phrase that's just intended to operate down the bottom as the, okay, you can do X, Y, Z, A, B, C, and a whole lot of other stuff as well. Okay, so there are a lot of things that judges need to get across when they're factoring in intention to create legal relations. The difficulty for judges then is that given there is this broad range of circumstances, how then do you go about prescribing rigid rules that would apply to kinds of cases? How, and this is where they start to segue into their question about the way the law's developed in this area, how can you say there are kinds of cases, brackets here, family, non-familial, social, business, how can you say that those broad areas or kinds of relationships should be subject to certain rules? Because human life is human life. It's extraordinarily varied in terms of the factual matrix that you'll get from case to case. Rules are going to be quite difficult to successfully apply. In fact, they go beyond this. They take one step further. And you don't see courts saying this very often, but they say to take that kind of prescriptive approach would be wrong. And that's not a word you hear very often. So then they say, okay, what is the standard? Given that we have to have this wide-ranging review of the facts, what is the standard? They hammer it home. They reiterate the obvious. Okay, the standard is an objective assessment of that state of affairs. It's not the task of the court to go about looking for some kind of uncommunicated subjective reservation, that is, you don't want it to be legally binding, or intention that it would be legally binding. You have to always stay objective in this kind of forensic inquiry. And then having step 1, step 2, step 3, this is how things are, this is what we need to do, these are the standards that we need to uphold. Then the beauty of the majority judgment unfolds. It's great to see because it's quite a good lesson, as I said, in judicial decision making. How do they go about doing it? A couple of things I just want to flag for your attention. They say, in the context of intention to create legal relations, there were frequent references to presumptions. What a lovely understatement. In fact, this area of law has been marked by the process of looking first for the category of relationship and then applying the right presumption to that category of relationship for donkey's years, time immemorial. And what a lovely understatement. People have been frequently saying that there are presumptions. Yes, they have. But we're understating it because what we are going to do is then gently sweep it out the door. So the first thing they do, and this is interesting to note, they pick on the big guy, the main category of relationship that almost without question has been subject to presumptions for so many years, family arrangements. Most people would agree, and I understand it says it in your study guide, that family arrangements deals between family members are not going to be justiciable. So they pick on the big guy and they say, there are presumptions that are floating out around the traps here. One of them happens to be family arrangements. It's like when the typical movie scenario when the main character gets dumped into jail for the first time and they're wondering how they can function in the jail environment, and someone advises them to, go and pick on the biggest, baddest guy, knock them out, and then that will establish their place in the jail hierarchy. I mean, this is pretty much what the High Court does in terms of knocking down the previous approach to looking at the facts to find an intention to create legal relations or not. So they say, here, another example of the kind of relationships that presumptions have been said to apply to is the engagement of a minister of religion. In both of those areas, it has been presumed that there's not going to be any intent to create legal relations. And then again, another lovely understatement. For our part, we doubt the utility of using the language of presumptions. Very gently, just massaging that previous way of doing things out the door. So they said, really, what do presumptions do for us anyway? Given that we have this wide range of facts that we need to actually go through and look at, what would a presumption do for us anyway? It would tell us who has the onus of proof in showing that, in fact, there was legal relations or not. In any event, wherever intent to create legal relations is raised, the person that's seeking to rely on the contract is the person that's going to have to go about showing that there was intention to create legal relations. So they're saying, well, really, it doesn't do anything for us anyway. Let's just get it gone. And that, my folks, is how the High Court does things, with much elegance, with much understatement, but with a lot of thought and power in the way that they go about explaining themselves. They've set themselves up. Here we know what the process is, we know the challenges, we know the standard, the objective inquiry that has to be made. We know that there is this prior approach in this area, but now we don't think that that's such a great idea anymore. So having set out for themselves what the general procedure is in cases of having to find intention to create legal relations or not, you might be asking yourself then why they didn't go back and forensically examine the facts for themselves. How did it all go down? What they do is they go back through what the industrial magistrate found. And the reason for that is buried away in a case called De Vries and A&R. If you've done a little bit of crim or evidence, you will know that there are things that appellate courts can and can't do. And one of the things that an appellate court can't do is very easily discard a trial judge's finding of fact. Okay, there are only very narrow bases for disturbing a trial judge's conclusions on matters of fact. As you can see there, a trial judge's finding of fact based on the credibility of a witness is not to be set aside because an appellate court thinks that the probabilities of the case are against or even strongly against that finding of fact. And why is that the case? Why is this so? Why is a trial judge's findings of fact so sacrosanct? If you go and have a look at the De Vries case, okay, so here's something I prepared earlier. This is the De Vries case. Just to quickly set out the principle that was at stake here for you in Homogenous, Dean and Dawson in their joint judgment go about explaining why a trial judge's decisions on fact is so important. An appellate court entrusted with jurisdiction to rehear a trial judge on questions of fact, they only set aside a challenge finding of fact made by the trial judge where it's shown to be actually wrong. Why is that? When such a finding is wholly or partly based on the trial judge's assessment of the trustworthiness of witnesses who have given oral testimony, allowance has to be made for the advantage that the trial judge has in seeing and hearing the witnesses actually giving their evidence. The value and importance of that advantage may vary. Now, if the finding is affected by error of principle or demonstrated mistake or misapprehension about facts, the advantage might be fairly minimal. However, if it's unaffected by those kinds of serious error, then it's going to be necessary for the appellate court to assess the extent to which it was based on the trial judge's conclusions about credibility of witnesses and the extent to which those conclusions were themselves based on observations of witnesses as they gave their evidence, as distinct from a consideration just of the evidence itself by the judge. Judges are increasingly aware of their own limitations and the fact that different people might present differently. A habitual liar might be confident and plausible, but a conscientious, truthful witness might be hesitant and uncertain. And it's really the trial judge that's listening to everyone give their evidence, forming conclusions about credibility that will then influence how the trial judge finds on issues of fact. Okay, they go down at the very bottom here to say, and this is the other joint judgment, if the trial judge's finding depends on credibility of the witnesses, that finding has to stand unless the trial judge failed to use or has palpably misused their advantage, that is the advantage in actually seeing the witnesses perform on the in the witness box, or has acted on evidence which was inconsistent with facts incontrovertibly established, okay, or which was glaringly improbable. They're really the only bases on which a trial judge's conclusions of fact can be disturbed. So if we go back to our Prezi, they're the grounds that I've popped in there for you. The trial judge failed to use, palpably misused their advantage, or it was inconsistent with facts incontrovertibly established, or it was glaringly improbable. So that explains why the court then went on to do what it did. I'll just take you to the decision now. Okay, so here we are at Homogenous. We've been discussing paragraphs 25 to 27 because they're really the only main paragraphs that are extracted by the casebook. So you can see how little we really get to see from the casebook. But anyway, they've set out what they need to do. They flip down, they talk further about the facts in the present case, and this is in paragraph 42 is where they say you need to think about exactly what we have to do here in terms of the De Vries case, okay? It's important to bear in mind the arrangement that the industrial magistrate found to have been made was an agreement between the appellant and the respondent, okay? That finding was based in part on the credibility of witnesses. What credibility of what witness? The appellant's, Homogeneous's evidence of what was said at the meeting in Adelaide that was held soon after the appellant's arrival in Australia. It was not a finding which was open to appellate review except on the well-known and confined bases described, for example, in De Vries. Okay? The main reason why the Supreme Court had allowed the appeal to it was because they said, big problem here with the industrial magistrate's initial finding, and that was he didn't actually go ahead and consider the whole question of intention to create legal relations. And the High Court says, well, that's rubbish, actually, because that whole issue is bound up in the question, can a minister of religion be in law an employee? Now, employee itself carries the connotation of a legally justiciable contract between an employer and an employee. So they said, no, there has been this meeting at which this evidence has been put before the trial judge. It depended on credibility of witnesses. You can't then go ahead and chuck it out. There was no manifest error here in terms of a failure to consider intent to create legal relations because it was right there in the question that the industrial magistrate posed for himself. So what does the court do then? They go ahead and they basically conclude that this particular decision has been arrived at appropriately. The one question that was really left to be answered was only the very minor question of, all right, if there was a contract here, was it a contract of employment? Because the answer to that question would then give Archbishop Homogenous either his annual leave and long service leave money or not, okay? And they say, well, this thing has already been through so many levels of appeal. Given that we have now just unpicked the very basis for which the full court of the South Australian Supreme Court granted leave to appeal, is it really worth going back and re-hearing this matter all over again at that level, the full court of the SA Court of the SA Supreme Court, or do we leave it as is? It's going to have to go back down to the full court of the SA Supreme Court for determination of that issue, but this is what we think is the case. So if we segue back to our prison now and we look at the remaining judgment, which is Kirby. So what did Kirby say? Well, there's a couple of things that I want you to take away from Kirby's judgment. Firstly, he gets the business out of the way. The whole reason why the full court of the SA Supreme Court unpicked the findings of the Industrial Relations Court magistrate was because that they thought there was no consideration given to the issue of intention to create legal relations. However, Kirby pretty much says straight off the bat, yes, it was considered. That question of intention to create legal relations was bound up in the issue of the magistrate working out whether or not the Archbishop was an employee or not. So he gets that out of the way. Paragraph 74, I want you to have a look at that. He basically says that there's no presumption that contracts between bodies and ministers of religion have no intent to create legal relations. Now, that's quite a bit narrower than the majority's rather sweeping discussion of the procedure, the correct procedure for going about working out whether or not there was an intention to create legal relation. Kirby restricts himself to just looking at the ambit of this particular matter and says, in this particular case, between bodies and ministers of religion, we're not justified in applying a presumption. So that's Kirby's take on that issue. Then he goes down a little bit further and says even people of a spiritual vocation normally need stable arrangements for the necessities of life. And he goes and has a little look at some of the facts in the trial judge's decision. So it was things like being persuaded to leave his secure post in the US and come to Australia. That was an important or substantial arrangement for necessities. And Kirby had just finished saying, well, even if you're a minister, you're still going to need some security around arrangements for your necessities of life. So when you're undertaking a major decision like to move countries for your employment or for your calling as a minister, then there may well be intention to create legal relations. And for those of you that have read your text, you may find little flags going off in your head, some similarities with the case of Wakeling and Ripley. In that particular case, it was familial relations, but we had an elderly man living in Australia, invited his sister and her husband to come out and care for him until he died, promised various things if they did so, and the husband had to give up secure employment in England to come out here. Was there legal relations there? Yes, there were. And there was a justiciable contract in that case. So it's not a wasted exercise by any means to go through the text and look at the various categories of relationship that used to be brought into the process of finding intent to create legal relations previously, because you do find nice little handy streams of law that you can tap into and see if there are any ties to the case that you're looking at. So here we had something similar. The Archbishop left the US to come out to Australia. possibly that might be an indicator of intention to create legal relations. Other things Kirby points to in the conclusions by the trial judge on the facts, things like it was already conceded that the community employed other priests. So then once you've done something like that and you've admitted that you've employed other priests that have a similar spiritual calling, how then do you distinguish between the archbishop and the priests? It's a bit artificial. Other things like payment of salary, payment of checks for travel, the arrangement for payment of PAYE tax and what was stated on the tax forms, all of these things tended to indicate a legally binding contract. And very importantly, it's all couched in terms, as I said, of what the trial judge came up with, and that should never really have been unpicked by the full court of the SA Supreme Court. Interestingly, at the very end, Kirby puts in a little thorny question, which is, okay, we still do actually have this little issue left, which is, okay, there might be a contract on foot, but was it a contract of employment? And he says the matter is arguable. And the whole reason I'm saying that the matter is arguable is because the majority have indicated they don't really think it's worthwhile sending back down for any decent exploration of the matter at the SA Supreme Court full court level. He thought that there was sufficient, in there to warrant a further discussion on that at the lower level. So that was Kirby's decision, and that is the Homogenous case. Hopefully you will come to appreciate that there are a whole stack of reasons why it's very useful to read the full case online on occasion where you have a particularly important decision like this. So that's Homogenous. We'll wrap up this video here and we'll come back for the final part 3. It'll be very short, I promise, folks. Okay, see you soon.